for entertainment purposes only. And if you want true legal advice, contact your own lawyer.
Radio Law Talk. I like that show.
Radio Law Talk. Now, back to the show.
So we're at picking the jury in the Weinstein trial in New York, and there's two things that the attorneys have. They can kick someone off for cause or what's called a preemptory challenge. In New York, it's 10 to 20 preemptory challenges for a felony. Probably this one has 20. Todd and I were talking about it during the break. We're not sure. Which means for cause, the attorneys can say, look, there's an obvious, the guy stands up, and it's a guy, and he says, I'm a New York police officer. Well, that's for cause. I mean, clearly that person will have a very difficult time being neutral. Or, I am the brother of the defendant, that's for cause.
And there are even some who just put on the jury questionnaire. In the jury questionnaires I've typically used have a question that says, can you be completely fair and unbiased? And some people say, no, I can't.
Right.
Like, look, if I am of the assumption that the person sitting next to the guy that keeps jumping up and down saying objection, and the person who's called the defendant, we wouldn't be here if they didn't do something wrong, and I have a hard time being fair and objective. And look, those people are dismissed for cause.
And that judge has to decide that. But the preemptory challenges, let's just assume they have 20. The sides can kick off, and they really don't have to say the reason why they're kicking them off. They just say, we like to thank, the typical saying is, we'd like to thank and excuse Mr. Todd Cunin.
Exactly.
And that's it, and they walk off. They don't say a reason or anything like that. And in this case, the prosecutor saying Harvey Weinstein's defense counsel is kicking off white females that are young. I mean, basically, and then they're arguing, well, because they're millennials and they're not they're kind of follow the Me Too movement type of thing.
You know how some states are at will employment.
Yes.
So which means that your employer doesn't need a reason to let you go. They can just let you go. However, if you can prove that the reason the employer let you go was because of your race, because of your religious beliefs, because of your protected class is what they call them, then the employer has violated the law, even in an at-will state. Removing jurors from a case using peremptory challenges is the same thing. I don't have to state a reason, but if the other side can show that the reason I am doing that by a pattern,
it's pattern.
That the reason I'm doing it is because of a certain characteristic that's protected, then I've got a problem as an attorney because the other side files makes what's called a Batson motion, which refers to a Supreme Court case, U.S. Supreme Court case, where the court initially said you can't do that for race. You cannot exclude people on the basis of race. Interestingly enough, one of the dissents, I think it was Justice Berger in the dissent, said, well, if we agree with this, then people will be able to bring a motion if they can prove that folks are discriminating based on gender. Now, this case was like 1980. 1994, U.S. Supreme Court expanded Batson and said, yeah, you can't remove them for gender either.
Yeah. Yeah. So.
And that is what the prosecution is saying here, is that the defense is removing people based upon their gender and arguably their age, but primarily their gender, white young females, and the defense has to answer to that.
And here's what's interesting, as I alluded to before the break, this is one of the arguments they make. They said the following, get ready for crickets on this one. This is a cricketer. The prosecution said, Your Honor, here's an example. They excuse a woman who said she had friends who were sexually assaulted in college. Yeah. I mean, so as an attorney, you have to be neutral. You listening out there, look, as an attorney, of course he's going to kick that person off because that woman, I think, is going to have a difficult time not remembering her friends being sexually assaulted, and for them just to say, well, I'd like to thank and excuse you. Maybe that's a reason they think that, but for him to say that, the prosecutor, I think, come on, guy,
Yeah, if the defense can make some sort of reasonable explanation as to why they dismiss somebody, the Batson motion should be denied. But that's where it gets a little bit difficult. Sometimes when they go through jury selection, all they mark down on their little Post-it note that represents each jury maybe is a little mark that just like, I didn't like this, and they remove them. If you're an attorney and you don't keep notes as to why you dismiss somebody even though you don't have to tell the court. And then the other side files a motion claiming you're discriminating in the removal of jurors.
That they see a pattern here.
Yeah,
right.
And if you can't remember why you dismissed each juror, you got a problem, Cal.
Well, the question is, how does Harvey Weinstein get a jury of his peers? He's got to find a bunch of old, white Hollywood men who are accused of sexual assault.
That's right.
Well, that's not what the Constitution says. That's not what it says.
I know.
But here's what's interesting too. And another one, the prosecutor argues, just a little anecdotal, interesting stuff is, well, you kicked off another female that because she was writing a book about the assumptions of women in the workplace. Well, come on. Well, of course, are they worried about that woman having a little bit of a skewed, belief? And the answer is yes. And but anyways, we're going to get to some more stuff.
Yeah.
But the judge said no.
And on that one there,
Yeah.
look, the jurors are given a specific admonition that says, there's usually a period of time, 90 days, before you can release any, book deals or pay for, do anything, give interviews or anything like that based upon your jury service, and you're not supposed to be consulting the media. And if you got somebody that comes in and specifically says, I'm writing a book.
Yeah. About something like this in the workplace.
How do you not, as an attorney, have concerns that this person is going to be thinking more about what they put in their book than about whether or not this person has been proved guilty beyond a reasonable doubt? I'm not defending Weinstein. I'm trying to defend the impartiality of the process.
And that's why I think what the prosecution brought forth, from what I've seen, again, we're looking at a small portion of it, just so you know, and we're being general. But what I've seen is like, come on, really? And luckily, the Judge Burke says, no, we're denying your motion, your objections. Move on, counsel. Because I know there's a number of, I know there's three men are white. I mean, during the middle, I can't remember exactly what the final breakup of the jury is, but 3 men are white, an African-American man, 2 women are African-American, 1 woman is an African-American and Latino. It's a mix.
And right now they're only through 7. They've only picked 7 people. They still have 5 more to go on this one.
I think they actually, as of Friday, they finalized.
Had they finally?
I think by Friday they finalized it. We're going to get into that. But here's one interesting thing that the judge stated. And this is, we're walking you through. We talked about Monday, Tuesday. This is Wednesday, Thursday, or I believe it was Thursday. Judge Burke advised the jurors this, and this is interesting. Advised the jurors, quote, this, ladies and gentlemen of the jury, is not a referendum on the Me Too movement. So he basically admonished them to this is not about Me Too. And this is about what this individual,
this narrow slice
this
here.
person, and how his life is or will be affected, and how these women's life were affected if anything occurred.
With all the time this takes, do the hourly charges, do you charge for extra for court time, or is it the same as a regular hourly charge in a case
I can answer that question.
Yeah.
Most of the lawyers I know that are defense lawyers, now if you're doing a personal injury case like us, it's straight contingency. But lawyers do charge a higher rate, generally speaking, for trial time. And it's not a little more expensive. It's a lot more expensive for trial time.
So you got prep time, that's one rate, and then you go into the courtroom, boom, the meter is like after the latest PG&E rate increase. It's really spinning.
Usually it spins pretty hard, and that's exactly it. Okay, so then we move on to, and we're running out of time, and so you're going to have to join us on our next segment. Harvey Weinstein finally now they get into the questions of the jurors. So, and they've got most of them chosen. Right now they have 7 male jurors and 5 female jurors. So that's the 12. So they've got their 12 jurors right now. But some of the questions they asked to get those 12 jurors is interesting. And that's the stuff we're going to go into next hour. So join us for hour number 2 of Radio Law Talk. We appreciate you joining Todd and I and Cal. We have gone off the rails a few times. It is very clear we're doing better than I thought, Todd.
Exactly. And when we talk about next segment with that, I'm also going to talk about some things that I've encountered during jury selection and whatnot. I couldn't wait to use whatnot.
Yeah. He used the whatnot. Cal, is it time for us to go away?
Whatnot is a critical word in this program.
Yes.
You have to be able to use whatnot.
Join us next hour. Call us at 855 529-7234, or tweet us at Radio Law Talk. We'll be back second hour.
By the way, it's 7236.
Oh, 7236.
Yes.
Okay.
Speaking of charges, I'm sure you charge extra for whatnot, don't you? I'm just wondering.
Or you can call 34 and see who's on the line, Todd.
We'll be back with more Radio Law Talk after the top of the hour break.
Hey travelers, do you want to save money on your next flight? Then pick up the phone and call. That's right, call, because the best prices are not online. They're with SmartFares. See, SmartFares has special deals with the airlines. When they have unsold seats, they use SmartFares to fill them. So you get airline tickets at ridiculously low prices. Our prices are too low to publish online. With the extra money you'll save, you can book another trip, or treat yourself to dinner or shopping. So stop searching all of those travel sites to find the lowest price on your next flight. Let one of our SmartFares expert travel agents find ridiculously low prices for you. Call SmartFares today and get the best price on your next flight. Guaranteed. Also, save up to 50% off business and first class tickets.
800-871-3291. 800-871-3291. Again, that's 800-871-3291.
One. Ladies and gentlemen, the following is a live copyrighted presentation of Radio Law Talk Incorporated. It's time now for Radio Law Talk on RadioLawTalk.com. And now, here is your host, Frederick Penney, attorney at law.
Yeah, you got a couple of buffoons here trying to figure out how to go live on my Instagram, but I did it the other night, Todd. I went live, but I don't know.
Food goes in here. That's where I get really
that's
basic.
what we can do. Welcome to Radio Law Talk, hour number 2. Not quite as exciting as the first hour in my voice, but I will ramp it up. 855 Law Radio. And Todd was wrong last hour. Todd said it's 855-529. It's 7234.
I know. I was wrong.
You should never question me.
I shouldn't.
Just
Look.
follow what I do, and I've got it. So anyway, 855-529-7234. Even if you don't want to talk on the air, Cal will take whatever suggestion
Gladly.
or whatever you want to talk about when it comes to case or no case. This hour, Cal will have another case or no case for us. We're going to continue talking about Harvey Weinstein. Those of you who didn't join us the first hour, which most of you probably have, we're continuing to talk about the trial that started in New York, and we're talking about voir dire and how that works, and the system of the choosing of a jury. We're going to go through some of the questions they're asking. And the interesting thing about the questions they're asking is sometimes it sheds light on what their arguments are going to be. And you're not supposed to argue your case in voir dire. That's the rule.
Yes.
But you can tell how the questions are asked is to some degree an argument, or saying, look, this is kind of what we're going to say. I want to make sure you're not going to be prejudicial to us if you're going to say that. And we're going to discuss that in more detail. We're also going to talk about Avenatti is in trouble again, and the latest with that, and the California sit-in moms lawsuit, climate change kids lawsuit. Those are all coming up this hour, hour number 2 of Radio Law Talk. And we had someone tweet in and say, or tweet, did they tweet or they texted or emailed or tweet? And they said, you know what, we think Mr. Penney at the beginning of the first hour said it was January 29th.
September 29th is what they said.
September 29th, 2020.
Well, last week he said it was November, so it's okay.
So if they said it was September 29th, 2020, if that's what I said, we're going to fast forward ourselves to September 29th, 2020, and we are going to predict the future. That's what we're doing here. Harvey Weinstein. I know some people think we're beating a dead horse. We're not. When you pick a jury, and that's what they're finishing up doing, is picking a jury, you usually have to ask questions. And when you ask questions of the jurors, sometimes that tips you off as a reporter as to what they're going to argue in the case. And some very interesting things that the defense and the prosecutor questions are asking. And let's go through a few of the questions with Todd, my compadre here, and let's ask ourselves if we can kind of read between the lines, or as Todd says, read
The tea
leaves. And this is very interesting. There's now, I've heard people say, oh, well, I know what their key arguments are due to the questions that they're asking during this trial. No, you don't. There's going to be other things, but it gives you a little bit of flavor, right, Todd?
Exactly.
And here's the first question that the defense is asking in the Weinstein case to the potential jurors. One is, does anybody on this jury think that it's possible that an individual can say they were sexually assaulted when they really weren't? And so what are they insinuating, Todd? What are they insinuating there with that question? What are they trying to say?
Is it possible somebody can lie about sex, that they were
assaulted
sexually assaulted?
Yeah, in other words,
yes.
These people that are coming before us, you don't have a problem saying that they lied, do you? About they were sexually assaulted. That's what they're trying to and what they're trying to do is just plant that in their minds.
And that's an interesting tactic, because there will be people that are on the jury that will say, look, I don't want to decide this way because I don't want to call that person a liar, right? They put two and two together. I don't want to call them a liar. I just don't believe their story. And this question is a creative way to say, hey, here's a way that you can say that it didn't happen without necessarily calling them a liar.
Right, because you said in the beginning, yes, I can find someone that doesn't lie, but they truly believe that they were assaulted, but it didn't happen.
Because it also opens the door for people who, like, as you said, believe they were assaulted, but when it comes down to it, they didn't. I think this is starting to lay the groundwork. Remember, there were the motions pre-trial about whether or not somebody could come in, experts could come in and testify about, what was it? People, not everybody who has sex against their will is raped. Right. Because there are people that just do it because they have another motive, something else they want to do, or these are all getting into the areas of pretrial motions that we had heard about in the past.
Cal, I want you to there's going to be a lot of things that after I read these questions, you're going to have to throw some really interesting sayings. So stay alert as to what you think applies. Here we go. Number 2, does anybody think it's possible that someone can have sex with someone they may not find attractive for things other than love? How about money?
Yes. I'm sorry, but look, there are. Has anybody ever heard the phrase "gold digger"? You know,
and we're not saying that.
And I'm not saying that that's the case. But if you've ever heard the phrase "gold digger," you are essentially referring to somebody that will engage in that conduct for reasons other than love.
And again, we're not saying this occurred here. We are just stating what the defense is asking. These are questions they're asking, and that's kind of a tip to say, this is what they're going to insinuate in their arguments. Okay, number 3, does anybody think, and these again, we're talking about the jury questions from Weinstein's lawyers to the jurors. Does anybody think that a person had consensual sex can change their story years later to turn someone into a... Now, what is a pariah?
Pariah.
What's a pariah?
A bad person.
Yeah, a bad person, a scourge on society.
Turn someone into a bad person and say what was once consensual, and then say it's something different.
So you're telling me there's a chance?
There's a chance. There is a chance. Those of you who are listening live, he did say so. There's a chance. Make sure you can play that up here, Cal, on our speaker. Okay.
With the other questions, the other 2 that you asked, there are multiple interpretations about whether or not it's calling somebody a liar or not. And this one here. This one here is pretty specific given how long the question is and the multiple parts to it. But to say, hey, do you think that somebody can have consensual sex and then later say it wasn't consensual because they want to turn somebody into a pariah and say it was something else? I mean, that is essentially them saying the folks you're going to listen to have a motive and they've lied to change your story and doing everything.
And that's what they're trying to set up. Now, don't forget, we're going to what the prosecutors are saying too. But there's another attorney. Don't forget, there's multiple attorneys representing Mr. Weinstein. And here's the next question. The next attorney for Weinstein says as follows. He says, This is a he said, she said case. Let's see. They would be trying a he said, she said case. That's what he's telling the jurors. That lacks video or audio evidence, and basically caution them, do not take the prosecution side by virtue of the sheer number of individuals testifying against Mr. Weinstein.
Do any of these people bring along any convenient DNA evidence or anything like that, or is it all?
No, this is a he said, she said case.
So
That's
he
what's
says
going
no,
on.
there's no
There's
physical
no
evidence.
DNA in this thing, and in fact, I believe that many of the witnesses here and or ladies claiming the sexual harassment and sexual inappropriate sexual conduct it did occur. And it's not like did this occur? It occurred, but against their will is the argument.
Yeah, and those last two questions that you just read, those are also very similar to what are commonly found in jury instructions, where the court specifically advises jurors, don't just count the number of witnesses and make up your mind, okay? And statements attributed to somebody else that are not recorded should be viewed with some caution about their veracity, okay? So I get those questions. They're very close to jury instructions.
All right, we're going to be back, and we're going to talk about what the prosecutor asked the jury, and there's telltale signs of what they're arguing. We're going to be back after these messages.
Thank you for listening to Radio Law Talk. It will continue in just a little bit right here, so don't go away.
Is this real life? Oh, come on.
Radio Law Talk. Now, back to the show.
Welcome back. We were talking about Weinstein, and we're going to get into some voir dire questions that the prosecution discussed and kind of look at the behind the scenes, and then we're going to move on. We're going to talk about Avenatti. There's some issues going on in Avenatti's case now that just never ends. That lawyer never ends. But by the way, I think he was a very wealthy attorney, and now he's almost broke, and they're going to talk about why he's almost broke. But Todd, that we've got on the Weinstein issue, we were talking about what the defense asked, and there's one question the defense asked that we forgot to mention that's interesting. Go ahead and bring that up.
So this question it's as follows, quote, does anyone think that an individual who's a young actress or actor might, for whatever reason, potentially have a sexual interaction with an older man for a reason other than love? This, quote, close quote, this is the casting couch question. And, do you think, I think what they're getting at is, do you think that somebody would sleep with the older guy who's a movie producer because they think it's going to help their career? That's essentially how I interpret this question. I think it's a legitimate question. I think that to not go there would be to ignore the reality of maybe what goes on. The difficult part with this, though, is that it's a two-edged sword because, look, statistically speaking, there are people out – anytime you have a case where you have victims like this, there's a high likelihood that not all the victims who have ever been victimized are represented in this case. But by the same token, there may be a good number of people out there who engaged in this conduct with Weinstein and did it completely consensual. They ended up getting a movie deal or helping out their career, and they had no problem with it.
I could have written the question better. Do you accept the premise that sex for movie parts is the way business is occasionally done in Hollywood?
Exactly. That could be it. The problem where it becomes a two-edged sword is this. First, getting people to come in and say, yeah, I slept with Harvey Weinstein so I could get a role, may torpedo their career going forward. All right, that could have an adverse effect.
Wait, did you say get a role? I'm just asking. Okay, go ahead.
The other part where I think it could really hurt him is the prosecution can come back and say, yep, look at this. They had 50 people come in and say that they got roles. So Harvey Weinstein essentially thinks, I'm entitled to do this. This is how I go. And he doesn't care if somebody consents. He just assumes that every woman who wants to talk to him wants to sleep with him to get a role. Or to get a part in a movie, and he doesn't even care whether they consent or not. He just thinks he's entitled to do this because he's a movie producer. That's how the prosecution would try to spin that kind of an argument.
Right.
And so you're playing with fire here if you go down that road too far.
Yeah, and it could take a jury off. Don't forget, they're balancing. not making a jury mad. That's exactly what you got to be very careful of, is not making a jury mad.
That was essentially how the prosecution dealt with the Kobe Bryant case.
That's
Remember
exactly
back in the day?
Yep.
Oh, he's an athlete. He just thinks he's entitled to do this kind of stuff to folks. And that's what they'd be arguing with Weinstein. So playing with fire.
So we're talking about now what the prosecution asked the jurors as potential jurors. And by the way, they've chosen the jury. We're just talking about what the questions were. Number one, the prosecution asks mentions a testimony of a single individual is legally sufficient to find a defendant guilty of sexual violence. It doesn't have to be multiple people, and that's what they're arguing. And then the prosecution goes on and says, you have to really believe a person who is testified. In other words, but at some point they say you have to really believe a person. It's a he said, she said, and it's okay to believe one person over the other, is what they said.
Now, the biggest difference I see between the line of questioning from the defense and the line of questioning from the prosecution is this. These questions that are asked during voir dire are, by law, supposed to only go to whether or not there can be a challenge for cause, which means challenging a juror because they would not be able to perform their function as a juror. And quite frankly, the law says, the jury instructions say that the testimony of one person is sufficient. And if you as a juror say, nope, I'm going to need more than one, then you're requiring more than the law wants, and you could be bounced for cause. You could be kicked off the jury for cause, not peremptory, but for cause. Whereas Weinstein's questions seem to come very close to that line and maybe go over it. They're aimed more at peremptory type challenges, even though legally all of these questions are supposed to only go to cause.
Now, here's the interesting thing, in my opinion, the most interesting question that the prosecution is asking, and what they're asking is as follows. They ask the following. They say, merely because somebody goes to work, right, and puts on a great face and doesn't necessarily dictate what's going on in their life doesn't mean they weren't sexually assaulted. And that's going to be the prosecution's key argument, because Weinstein's going to argue, look, number one, they didn't say anything about it. Number two, it was all fine. I'm going to show you texts and emails from them saying, I love you, Harvey. You're my buddy. I think that's what's going on. And the prosecution's got to set this up in their questioning of the jurors, which they're kind of arguing a little bit their case of, just because a person acts that way doesn't mean something didn't happen to them, especially women being assaulted by predators. And then they go on and say, the prosecutor, even though these women did not report this right away, again, it's something for you to consider, the jury says. You need to consider that, but you have to listen to the whole story and why they didn't.
There is going to be mud on everybody in this. I mean, this is going to be blood and guts and mud and rolling around the street, isn't it? Seems like to me.
Yeah.
There is. Now, I come at this from from an interesting viewpoint in the sense that when I was a prosecutor for about a 4-year period, I exclusively prosecuted sexual assault crimes, victims age 14 and over. This was all I did for about 4 years. And
in Tennessee and in California.
I did a little bit in Tennessee, but for the most part, I did it back in the state of California. And this is something that I came to learn as a prosecutor, where I think that if the defense is trying to challenge these people because they put on the happy face and they did if the defense is trying to challenge that, this is where the prosecution is going to come back. And it's what I learned as a prosecutor, and it's this. There are as many ways for a victim to act and react to being the victim of sexual assault as there are victims of sexual assault. There is no uniform way. It's a fallacy to say she or he did not act like somebody who was the victim of an assault. There is no uniform way. Everybody reacts to it in a way that allows them to survive and move on.
And I think the thing is, too, is perpetrators as well. Perpetrators of a crime, a lot of times the prosecutor will say, you didn't act like an innocent person. You didn't do this one little thing that, to me, would have been a means test.
Exactly.
Is that not true?
Exactly. It's the fallacy here is this idea that there is the way a normal person acts, and you deviated from that. Whether you're using it
in
to
a sexual assault case.
Well, and
any case.
I would say in any case. I mean, DUIs. You didn't pass these field sobriety tests the way a normal person would. Really? Because I know a lot of people that never drink, and they can't do those tests, okay? So it's this idea that there's some sort of normal baseline of people that you deviated from, and to the extent they're saying that a victim deviated from that, it's a fallacy. It's absolute fallacy.
So
Go to the website, radiolawtalk.com. That's radiolawtalk.com.